Okay, let's start it. Well, hello class, how are you? Hope everybody is doing well out there. Today we're going to start a new topic, and the new topic is going to be an introduction to law and the courts. And as we start this topic, if you remember back to our systems model, now talking about specific American political institutions. So we're going to talk about the courts, we're going to talk about the presidency, and we are going to talk about Congress. But we're going to start off with the courts. And in talking about the courts, we want to approach it from a broader perspective, and we want to talk about law and the courts. So the first question we're going to look at is, what do we mean by law? What is the law? And the point I want to emphasize here is that law plays a central point in all of our lives in the United States. We are a nation of laws. Laws tell us what we can or can't do, what's appropriate, what's not appropriate. And they have impacts on almost every element of our lives. And our legal system is constantly making important decisions that impact us. And these decisions help define our liberties and rights as citizens of the United States. And as your book notes, judges confront conflicting values in the cases before them, and in crafting their decisions, they make law and they make policy. And this law and policy that is decided by the courts is binding on us, whether we like it or not, whether we agree on it, doesn't matter. It's binding upon us as citizens. So for example, if you look at decisions that have been made by our courts over the last 10 to 20 years, they've addressed issues such as, can same-sex couples be married? And obviously, our legal approach has transformed dramatically over the last 20 years. Can high schools and or colleges require drug tests of their students who want to participate in extracurricular activities? Can the police randomly scan cell phone waves and use that information against us in a criminal case? Can a state legalize the recreational use of marijuana if it violates federal law as a criminal drug? Can school prayers be banned? Can law schools and medical schools institute affirmative action programs? Can you, as a prospective employee, be required by your employer to take a lie detector test when you apply for a job? What's the legal status of abortion and late-term abortions? To what extent can musicians and their lyrics be banned and or censored? Can cities institute random traffic stops? So we used to do that, obviously, some cities would do that for alcohol to determine whether or not people were driving under the influence. Could we do it now for the coronavirus? Just stop people and say, look, we want to give you a quick test here to make sure that you're not positive. Can police randomly use thermal imaging devices to detect if someone is growing marijuana? So they just drive down the street with a thermal imaging device, pointing it at every house in areas that they feel are high crime rate areas. So in attempting to address and understand these types of issues, we're going to do the following three things. First, we are going to ask and define what is law. And in defining it, we're going to ask what types of legal distinctions do we make when defining law? And I'll explain that in a second. Then we'll ask, how does our judicial system organize itself to interpret and apply the law? And we have a federal legal system, so we'll talk about national courts and state courts. And then the last thing we'll talk about when we talk about law is how has the United States Supreme Court applied their authority pursuant to what we'll refer to as judicial review to substantive areas of law, specifically civil rights. So how have civil rights changed throughout the course of our legal history? Civil liberties. So let's start with what is the law? And we've already talked a little bit about the pervasiveness of law. So let's define it. Law has been defined as a uniform system of authoritative rules which govern and prescribe social behavior for people living within its jurisdiction. I'll say that again. Law is a uniform system of authoritative rules which govern and prescribe social behavior for people living within its jurisdiction. So let's take a quick look at the component parts of this definition. So we're saying law is authoritative. And what does that mean? It means that law is legitimate and it has binding legal force. We must comply with it. Prescribed social behavior, what are we talking about here? We're saying that the law can impose values, impose ideas of what is right and what is wrong in our society. And it does this in some of the most intimate parts of our lives. So we're constantly making laws that affect values. Who can you marry? So we have laws that define who you're allowed to marry. We have laws that say you cannot enter into a polygamous relationship. Well, why not? If we have a situation where the men and the women involved in polygamy are willing participants, why not let them? Well, again, according to the laws of our society, that is illegal, and if you do it, you can be prosecuted. And the same thing's true with lots of aspects of our life. So even religious worship, we can regulate aspects of that. So one of the famous cases here was Smith versus Oregon Employment Services, where there were American Indians, and central to their religious practice was the smoking of peyote. And the state of Oregon said, sorry, you can't smoke peyote, that's illegal. And they said, but that's our religion. And the Supreme Court upheld Oregon's law. So that's what we mean by law. Now the question is, what are the major types of law? And there's two major types of law that we'll talk about. Criminal law and civil law. Criminal law and civil law. What do we mean by criminal law? What do we mean by civil law? So let's use an example. Let's assume that you're a football player. I know we have a couple of football players in this class. And you're an offensive lineman. And the defensive lineman who's against you is beating you every single play and sacking the quarterback. and the coach calls a timeout, brings you to the sideline, and says, boy, you really stink. You are not being physical enough. So now you're psyched, you go back to the huddle, you say, I'm going to kill my guy on this next play. So they hike the ball, you come off really hard, off the line of scrimmage, smash into the person, and break their neck, and they die. Is that a crime? Is this a case of criminal law? Is this a case of civil law? Is it both? Well, let's define what we mean by criminal versus civil law and get a sense of where this might fall in. So criminal law has been defined as violations against the public order. It is viewed as a violation against society, not just a particular individual. Criminal law prohibits certain conduct and provides for punishment for those who engage in that prohibited conduct. So criminal law is generally characterized as the state versus the individual. So in other words, the state, the government, can legitimately say to us, you cannot do these certain things because it's a violation of society, it's a violation of public order. And if you do those things, we can prosecute you and we can put you in jail. And oh, how authoritative is government? Well, depending upon how significant the action is that you take, the government can even give you the death penalty. Many states still have the death penalty. So it can even take your life. Civil law. Civil law is different. Civil law deals with private disputes. In other words, it addresses disputes between individuals. So when we talk about private disputes, we could be talking about things like violation of a contract between two individuals. We can talk about an accident. Those kinds of things. So the civil law defines relationships between individuals, and it defines their respective legal rights and obligations. So civil law is trying to resolve disputes between individuals. If my neighbor has an apple tree that's growing over the fence and it's dropping apples in my yard, and my dogs and cats are eating these apples and getting sick from them, can I cut down the branches of his tree? Can I inject the tree with a poison that's on my side of things, which will eventually kill the entire tree? Well, that's a civil dispute. And the courts want to resolve disputes before they lead to something more. So civil law gives us an orderly, systematic, predictive way of resolving these kinds of disputes. And civil law disputes generally seek either monetary compensation, specific performance, so we need you to do something that you won't do, it's in your contract that you're supposed to build this, you don't want to build it anymore, or it defines a certain legal status, owner, trespasser. And civil law is characterized as individual versus individual. So it doesn't implicate society in general. So these are the two major types of law. And now we want to ask the question of how are decisions made in enforcing the law? How are decisions made? So I can ask you, as a student, do you want to abide by the law? And I think almost everybody would say yes. Okay, so then the second question that I would have to ask then is, how do you know what the law is? What is the law? And then how are decisions made in regard to enforcing that law? So first we have to know what the law is, and that gets to ideas of sources of law. Sources of law. Legal decisions are made by our courts, guided by written law. And the written law can be contained in a number of different sources. The United States Constitution is a source of law. And in our country, it's considered the most authoritative source of law. So if the Constitution addresses an issue, its definition of that issue, its resolution and approach to that issue is binding on all of the states and on the national government, and is superior to any other kind of law. But the point is, the Constitution in and of itself, although it addresses issues of civil liberties and civil rights, for example, is not a complete compendium of all legal concerns and issues. As a matter of fact, it only addresses a very few legal issues. Which means other sources of law have to be more specific and have to fill in the blanks. So what are the other sources of the law? Well, the second major source of law, and second most authoritative source, is what we refer to as statutory law, or statutes. Laws passed by legislators, whether they're state legislatures or national legislatures like the United States Congress. And these statutes can deal with issues of either criminal or civil law. Then we have what's referred to common law. So that's the third major source of law. Common law is also referred to as judge-made law. So it's prior judicial decisions made by judges in similar cases tried over the years. Judge-made law. And then the last source is what we refer to as administrative law. So law made by the executive branch. And some people in this context would include executive orders. So President Trump has been issuing tons of executive orders. In applying law, and these different types of written law, the courts rely heavily on a concept referred to as stare decisis. Stare decisis. What does that mean? Well, stare decisis literally is Latin and means let the prior decision stand. So when a court interprets the Constitution or constitutional provision or interprets a statute, maybe the Civil Rights Act, or applies common law approaches. What it does is it looks at how have we decided similar kinds of issues in the past. So they look at the precedents that they've set in the past. And what they attempt to do is apply the same strategy, the same approach, the same interpretations. And that's called stare decisis. Why do they do that? Why are they loath to overturn precedent? And there's good reason for it. Now, not to say that they don't ever overturn precedent, and we're going to talk about cases where the Supreme Court has done that. But they don't like to do it because they want the law to be predictable. It shouldn't vary from case to case. If you're doing that, there's something wrong with the legal process itself, say judges. So stare decisis is an important method to applying these different sources of law. And precedent, therefore, is very important. And precedent is a judicial ruling that serves as the basis for the approach that is going to be utilized in subsequent cases. Now, within this context, the highest national court in the United States is the United States Supreme Court. And its interpretation of the Constitution, of federal statutes, and federal common law are final and binding on all lower federal courts and all state courts. So this gets us to the next question, and the question is, how are our courts organized to make and enforce the law? And when we talk about this question, what we want to emphasize that in many ways, the American legal system is pretty unique, and it's incredibly complex. Much more complex than many other countries. And the reason is, our legal system deals with this notion of federalism and a federal approach to law. So the American federal judiciary gives us two distinct court systems. One is the federal court system, and the other is the state court system. So that's confusing in of itself. When do you go to one versus the other? Which one is more authoritative? And the answer to that question is it depends. It depends upon the issue. There is some overlapping between national and state courts, and there's some independent power between national and state courts. And there's certain things over which the national government and the national courts are supreme, and there's other things over which the state courts are supreme. So that's very confusing. So in order to provide some clarity, let's start by reviewing the organization of the United States federal court system. And probably the most important question dealing with the federal court system that helps us understand and define this relationship between federal and state courts deals with this question of federal court jurisdiction. And jurisdiction means the authority to rule on a case. So when does the federal courts have jurisdiction? When does it have the authority to rule on a case? What cases can be heard by federal courts? So when we talk about federal court jurisdiction, what we see is there's three types of issues that can go to federal courts. First, what we call federal question jurisdiction, or subject matter jurisdiction. So in other words, all cases that arise from the United States Constitution or questions about the Constitution or federal statutes or federal common law are tried by the federal courts. So first, federal question or subject matter jurisdiction. Secondly, federal party jurisdiction. So cases in which the federal government is a party. So if someone comes into alliance with a high-powered rifle and starts shooting people, the question might be, is that a federal case or is that a state case for the state of Ohio to prosecute? And the answer could be, it depends upon who he shot. So if he shot postal workers, well, then it's a federal case because these are federal parties. If he shot just regular citizens, students in Mount Union, not to be too morbid here, at that point it would be a state criminal prosecution. So those are the first two criteria. Federal question, federal party. The third criterion is what we refer to as diversity jurisdiction. Now what the heck is diversity jurisdiction? First of all, let me qualify it by saying that diversity jurisdiction applies only in civil cases. And it applies only in civil, again, not criminal cases, only in civil cases where there is diversity of citizenship. But what the heck does diversity of citizenship mean? All that simply means is that the parties of the case are citizens of different states. So one person may be from Ohio, the other person's from Pennsylvania, there's a car accident, and because they're from different states, one of the parties wants this case to be heard in federal court rather than state court. Well, the third qualification is okay, so not only do you have to be from different states, but the amount in dispute in this civil case has to be for $75,000 or more. So again, these are the three criteria for what determines if something is a federal case, whether or not there's federal jurisdiction. Federal question or subject matter, federal party jurisdiction, or diversity jurisdiction. Now, the good thing about this is once you come up with those three criteria, if it is not one of those three things, then by definition, the case must be decided by state courts. And when we talk about this distinction between federal and state courts, what I want to emphasize to you is that the severity of the case has nothing to do with whether or not something goes to a federal court or a state court. So it could be a mass murderer, but if all of these murders occur within the state, it is an issue of state jurisdiction. It could be a case dealing with hundreds of millions of dollars in a civil dispute. That would not make it a federal case. It would depend upon who the parties are. If their parties are all from Ohio, then the Ohio State Trial Court would deal with it. In this case, it would be called Common Pleas Court. Okay, so with that clarification, what I want to do next is talk about the organization of federal courts. So how are federal courts organized to deal with legal disputes in the United States over which they have jurisdiction? And when we talk about federal courts, and again your book talks about these different types of courts, and I think it's on page 375, There are three major levels of federal courts. So we have United States district courts, United States Court of Appeals, and the United States Supreme Court. So we want to look at these different levels of courts, explain what they do and how they operate, and how we get judges for these different courts. But just to give you a quick overview, the district courts are generally the courts of original jurisdiction, which means they're the first courts to hear a case. So in 2010, just as an example, there were approximately 376,000 cases filed in the United States district courts. And that sounds like a lot, and it is, but as a point of comparison, during that same year, there were over 100 million cases, 100 million, filed in state courts. So hopefully that gives you some sense of magnitude and how important the state courts are. I mean, through sheer volume, you would say, wow, the state courts are much more important than the national courts. And that's not necessarily true. Because a lot of these kinds of cases that go to state trial courts deal with minor kinds of issues. Parking tickets, speeding tickets, not that you guys would know anything about those things. So what we see sometimes is that the severity of the issue can be much more significant in some of the federal courts than the state courts. So don't be confused just by the sheer numbers. Well, let's look at these three different levels of organization of the federal courts. So he said that the district courts are usually the courts of original jurisdiction, which simply means they're the first court to hear the case at the federal level. District courts are the workhorses of the federal judiciary. They are predominantly trial courts. So these are the type of courts which citizens and students are generally the most familiar with.